appointer that can even call them to say this is where we are going, and all of them will go there like zombies. So what the National Assembly have been able to do is to remove the zombie concepts from internal democracy. So okay. no appointee now, because it is so clear that appointee, they have no mind of their own. They cannot, of course, it's so certain. It is what one man rules the party. But for the National Assembly to have such courage, to have made such law that will ensure that we don't have zombies voting in party primaries and party convention, they deserve this 21 gun salute for them.
Now let's begin today's conversation, taking our quote first from Dr. Goodluck Ebele Azikiwe Jonathan, Nigerian politician who served as the president of Nigeria from 2010 to 2015. He once said, "The stronger the bolt of democracy, the more it is able to meet the challenges of its voyage and deliver on its promise to citizens." Okay, so our second quote is from Franklin Delano Roosevelt, often referred to by his initials FDR. He was an American politician and attorney who served as the 32nd president of the United States from 1933 until his death in 1945. He once said, "Democracy cannot succeed unless those who express their choice are prepared to choose wisely. The real safeguard of democracy, therefore, is education." Absolutely spot on. Now let's see how all of this go to relate to what we will be discussing tonight. Very warm greetings and welcome to The Conversation. We're reaching you from Kaftan's television studio here in the nation's capital, Abuja. Of course, I am Annabelle Ojin. Now, the Supreme Court on Friday struck out President Muhammadu Buhari and the Attorney General of the Federation's suit challenging Section 84, subsection 12 of the Electoral Act. The case was expunged on the grounds that it lacks the jurisdiction to entertain the suit and is an abuse of court process. Earlier, a notice for the judgment delivery was served on President Buhari and the National Assembly, inviting them to appear before the court for the judgment. The president and his Minister of Justice, Abubakar Malami, had filed a suit at the Supreme Court seeking an interpretation of the controversial clause in the Electoral Amendment Act 2022. Now, in the suit filed on April 29th, Buhari and Malami, who are the plaintiffs, listed the National Assembly as the sole defendant. There have been several debates regarding Section 84, subsection 12 of the amended Electoral Act 2022, which was assented to in February. Now, upon assenting to the act, President Muhammadu Buhari had asked the National Assembly to delete the contended clause. However, the Parliament declined the President's request. Now, Section 84, subsection 12 of the legislation holds that, quote, "No political appointee at any level shall be a voting delegate or be voted for at the convention or congress of any political party for the purpose of the nomination of candidates for any election." End of quote. Now, in their suit marked SVCV 504-2022 and filed on April 29, 2022, President Muhammadu Buhari and Malami sought an order of the Apex Court to strike out this section of their Electoral Act, which they argue was inconsistent with the nation's constitution. The plaintiffs further contended that the Constitution already makes provisions for qualification and disqualification for the offices of the President and the Vice President, the Governor and Deputy Governor, Senate and House of Representatives, House of Assembly, Ministers, Commissioners, and Special Advisors. However, in its decision last Friday, the Supreme Court held that President Muhammadu Buhari, having assented to the bill on February 25, 2022, cannot turn around to challenge the same act. In a unanimous judgment delivered by Justice Emmanuel Ajim, the court said, allowing the suit to have its way will amount to approbating and reprobating at the same time, and no court of law shall allow that. The Apex Court unanimously agreed that President Muhammadu Buhari lacked the jurisdiction to bring the suit before it because of the nature of the reliefs sought. So, that has brought a lot of dust and fuss to the polity. And to help us make better understanding of the Electoral Act and its provisions, our guest on the show tonight is Dr. Olukayode Ajulo, counsel for the National Assembly. Dr. Olukayode Ajulo is a Nigerian lawyer, arbitrator, and civil rights activist. He is a fellow of the Chartered Institute of Arbitrators. We will be talking to him there in his Abuja office after this timeout. Do join us again. Welcome back. This is the conversation. We're reaching you from Catholic Television here in the nation's capital, Abuja. Our guest on the show tonight is Dr. Olukayode Ajulo. He is the counsel for the National Assembly. Great to have you on the show, sir.
Oh, thank you very much.
Great. All right, let's start by getting clarity of the Supreme Court's judgment over the suit by President Muhammadu Buhari and the Attorney General of the Federation on the contentious clause 84 subsection 12. The Apex Court, in a unanimous decision by a 7-man panel of the justices led by Justice Muhammadu Ajulo, held that it lacked the jurisdiction to entertain the suit, which is said amounted to an abuse of the judicial process. So, you were the counsel for the National Assembly. Help us understand what all of that is all about.
I am just wondering where one will start, particularly because it has to do with legal terminologies in different way. But I think I will try as much as possible to make it as simple as possible, particularly those who are watching, having in mind that most of your viewers are not lawyers. Now, the issue is there has been a lot of controversy about what the National Assembly, I think that will be one of their last acts of fashioning for Nigeria based on their constitutional responsibility, and particularly some provision of the Constitution that empowers the National Assembly to make law for internal democracy, particularly to make law for Nigeria, and as soon as possible, make law for the political party in management, administration of political party, and the way to ensure a smooth running of the organization called political party. Now, and one of what the National Assembly did is to pass the Electoral Act, that is 2020, which has come to be known as the Electoral Act 2022, in which, if you remember, it's off and on. Even I remember that some civil society and some group and stakeholders have been calling on the president to ensure that he should endorse the act, which shows that much time, premium time, was given to that act. And after signing the act, in which the president willfully, because there's no involuntary, willfully, here the president too, based on his what empowers him by the Constitution, in which every bill in Nigeria, before it can be turned to law, must have endorsement of the president, which is like a control. Like what I told the court, is like a quality control of ensuring that what is done has its accents, what is done has its own input, and to ensure that yes, we have a law in the country, which the president has done. But they could remember, as at the time of signing it, the president raised some observation. For example, section 84:12, in which he says that it may affect some people, it may affect their right and whatsoever it is. But by and large, the president endorsed the act. And after endorsing it, it's expected that everything will be allowed to rest. And we can see how different people go into court. But what surprises some of us is to see that the president himself and the Attorney General of the Federation approaching the Supreme Court, citing the original jurisdiction of the court. Yes, if you allow me to explain a bit, there are hierarchies of courts in Nigeria, from the magistrate court, which now is not even the lowest court. We still have some district courts, we still have some other court tribunals, but constitutionally, we have the High Court, we have the Court of Appeal, we have the Supreme Court. Cases of such nature, particularly when it comes to different interest parties, you start with High Court, then if after giving the judgment, if you are not ruling, if you are not satisfied, you can approach the Supreme Court to the Appeal Court. And when you are not satisfied with what the Appeal Courts will give you, you can approach the Supreme Court. This is the normal ways of things. But our Constitution allows some exceptional circumstances, special circumstances, where issue will come between the president and National Assembly or any organs of government, all the states, and that's why you see sometimes we'll be hearing is of Attorney General of Lagos State, Attorney General of Ondo State against the president. Most of all those cases, the original jurisdiction, instead of going to High Court before moving to Court of Appeal, is Supreme Court. That is what it is. And the president now purported, believing that this is the same thing here, now decided to take the president with the Attorney General now to the National Assembly, straight to Supreme Court. And when we receive it, having going through the whole processes, it was realized that it should not be. First, though, like what we told the court, it is not the wood that made the mock. It is not the way you see things that it is. If it is deeply investigated and interrogated, you will know that this is not the case. This case, who is supposed to be the party? The issue complained of, the president has no issue about it. There's none of the president's right that is being questioned. So the question we should ask is this: why in court? Why don't you allow those who felt aggrieved to go to court? And that's what we are saying. That position here is to the basic fact that the political appointee are those which the provision of the Electoral Act try to stop from voting or to be voted for in party congresses and anywhere such resolution or decision has to be taken. And if anybody should go to court, the president should not go on their behalf. The president cannot be reduced to representatives of anybody. That is one. And the president cannot say, yes, I'm acting as representing in represent capacity for those that can be ascertained that can go to court. So one of the first things we did is to raise objection on that fact that the party that holds to being in court is not in court. You can't say that because there is a law that says that whenever the president and the National Assembly, they have issues, you quickly rush to Supreme Court. Yes, it is, but not this kind of issues. We are talking of issues that affect either the office or the federation, not issues, because if care is not taken, if you allow the president to do that, that means that any Jack and Harry's cases in this country, the president will just take it. It's like, the president like your face, that means that anytime anything has happened to you, the president can quickly go to Supreme Court to say yes. You know what I'm saying? That's one of the things. So, in our response to what they filed, we filed 26 grounds of objection, part of which is what you mentioned about the fact that, first, this is not the kind of issues that the Supreme Court need to entertain. The way it is constituted, it is not. And basically, the president cannot take this kind of case to court. Why? Because when you look at our democracy and the way our constitution makes the lawmaking processes, after the National Assembly has already passed, bill, it still has to come to the president. The president has the final say in endorsing, and that's where his control comes from. You can't endorse a bill to make a law, and your heart, you now still decided to take it to the Supreme Court. The question is that for what? It's to me, and this is what was canvassed before the court, that this is a joint act. This is a joint act between the president and the National Assembly.
Okay.
The president cannot be seen now to now be suing his partner, because they are partners, because National Assembly and the presidency, they are partners in lawmaking process. So two partners cannot wake up after we have done the deal. One of the partner quickly now rush to court to say, no, stop it. It is not. You cannot be appropriating at one point and then you be deliberating. And as it is, the Supreme Court agrees with us. And most of the grounds of objection, like I told someone, until the full judgment is out, we can read it, we now know which of our objection the court agree with. And virtually all, because that I listened to the should I call it adoption of the judgment, you see that most of what we raise, it is what the court agrees. So I think that maybe I should use this opportunity to salute the courage and the industry of the my Lord Justices of the Supreme Court, because the premium time within a very few days, and that means that they are really ensuring, because when it comes to politics, when it comes to such issues, something that affects the generality of Nigeria, and the Supreme Court came all out to really resolve the issue. Though I must say this, the real merit of the case has not been addressed, and I believe their thinking is that there are still courts that can resolve this. So instead of to dabble into the issue, so far that they've already declined jurisdiction, that they have no jurisdiction, then let the main issue be resolved, but at least they resolve some certain issues.
So does it mean that it has actually not been completely resolved? It could be
it now depends on how it will be.
Okay.
It now depends on how it will be, because I remember that there are some matters in High Court, some in Supreme Court, in Court of Appeal, which is still on. But I don't want to speculate. As a lawyer, you are not allowed to speculate. It is what we discuss life issue. Life issue is that, and the court has already dismissed it. So as far as I'm concerned, nothing to discuss about today, except anybody should take it up again.
Okay. So now the National Assembly asked the Apex Court to strike out that suit accusing the President and the Attorney General of the Federation of abusing judicial process. How so?
Well, I don't want to raise the issue of abuse. The journalists have a way of reporting issue. I don't think I want you to know that the presidency and the National Assembly, they are partners. If you remember, the three organs of government where the entirety of the gravity of the nation rested on is the judiciary, the legislature, and the presidency. So they cannot at any time be seen to be at loggerheads. Whatever thing that is done for the development and the moving Nigeria forward. So the journalists may say they abuse, they accuse, they do anything. But what matters most, because when we say there is abuse of judicial process, is when the process of the court is not used in a way you believe and the way and manner that it is prescribed to be used.
Okay.
And when such an happens, it amounts to abuse. If a matter has to be filed somewhere and you file it in another place, it's abuse. If a matter is is one certain court and you quickly rush to another court to file yours, the latter one you file is an abuse. Okay. And if you bring a matter that is not on the face of it is not merit, should not be entertained, it's an abuse.
So this one is not an abuse?
Yes, it's an abuse.
Okay.
It's an abuse of court process, and the court agrees with us.
Okay.
That is why it was struck out.
Okay.
It was struck out. So the issue of abuse is not the way people say it, is the way that when a process of the court is used in a way that a manner that ought not to be used. Because if those that has the locus, they are alive, they can be ascertained, they sat somewhere, and you, the president, and the Attorney General of the Federation now decided to leave everything you are doing and to hold that one and quickly rush to court to say, yes, I've been offended, my right is on the line. Which right? Are you a political appointee? No, you are elected president. So that means that tomorrow, if the workers, maybe journalists have problem, the president will quickly go to court to say, journalists, you don't know. I don't think that's what Nigeria need at this starting time. And I think that's why we commend the justice of the Supreme Court for doing justice to that case.
All right, I'm going to ask you, and like also it actually states that an order nullifying the provision of that section 84 subsection 12 of the Electoral Act 2022 by application of the blue pencil of being unconstitutional, illegal, null and void, and having made in excess of the legislative power of the defendant and enshrined in section 4 of the Constitution as amended. In all of this, is this a victory for democracy?
It is a victory for the democracy because what the president and the attorney general is asking for is that provision should be expunged. And we've been able to let them know that there's no need for it to be expunged. And that is why the entire matter was struck out.
Okay.
And to us is a plus. It's a victory for democracy because the essence. I think we are missing something here. The essence of that provision is something that we need to. You can see the way immediately that provision come in. A lot of people praise the National Assembly for ensuring we have that provision, because the main democracy is from, you can only get democracy from the internal democracy, and once you cannot get your internal democracy right, you should be sure that the main one outside will be wrong. The essence here is most of these political appointees, by the virtue of their offices, they seem to have a strong position and have an hold on the party. Because, for example, if I'm a chief executive officer of my state, that is governor of my state, and I have nothing less than about 200, some of them 300 A's, chief of staff, commissioners, SSA, this, blah, blah, blah. And at the end of the day, most of them always believe that you find them in the party politics, and you pay the pipers, dictates it. If I as a president or as a governor, if I should tell those my appointee when we are voting tomorrow, this is where you should go, they dare not argue with me. Okay. It's a command. And what the National Assembly has been able to do is that these people, they are more or less, don't mind, sorry for the issue of that word, zombies. That is where you ask them to do. So the zombies, anyway, that is the word we use in political parlance, political party. Don't forget that I was once the national secretary of a political party. So most of those political appointees in party politics, particularly during convention or primaries, we call them zombies, because he who pays the pipers, dictates the tone, is the appointer that can even call them to say this is where we are going. And all of them will go there like a zombies. So what the National Assembly have been able to do is to remove the zombie concepts from internal democracy. So okay. No appointee now, because it is so clear that appointee, they have no mind of their own. They cannot, of course it's all certain. It is what one man rules the party. But for the National Assembly to have such courage, to have made such law that will ensure that we don't have zombies voting in party primaries and party convention, they deserve a 21-gun salute for doing that. And that is what they've been able to do. And unfortunately, some people want to reverse that situation, and the National Assembly has been able to stop that.
Okay, now let's talk about the National Assembly that you're talking about. Now, what exactly will be the faith of the National Assembly? That's one on the side. I'm going to ask you two questions, and I'd like you to take them in one breath. Now, what is the faith of the National Assembly? Seeing that a few days before the suit, they actually attempted to veto the president, but then they later reneged on that. So some people would have actually said...
let me quickly say something. You should know that I'm not working with the National Assembly. I'm just a council. And a council in which a brief has been given to. The brief is on that to defend the case in the Supreme Court. Any other thing, I will not be the proper person to talk about National Assembly in any way. Don't mind, don't forget that a lawyer will only represent the client to a point where you have been briefed and to what you have good knowledge about. And we are discussing this because even we would have discussed it if the matter is still in court, but as it is now, the matter is not in court. The court has given a final has given a judgment about that. So I can discuss it. But on this issue, honestly, except if you just want me to have my opinion about what National Assembly, what is happening.
Okay, who might get your opinion?
Okay, it's going to be my general opinion, like you and I, but to speak as a counsel to National Assembly on this issue you mentioned, particularly when one has not been briefed about that, it would have been a big issue. But basically, National Assembly has a power to veto the president. And meanwhile, you should know that when it comes to vetoing the president, it's issue of politics, an issue of agreement. And to consider what they need to do, look at the law, and to now use their political will, either let us veto it or not. And don't forget that sometimes there may not be a need to veto, particularly when they realize that there are many other ways to still achieve what they intend to do. They can look at the bills and try to amend it and then bring it back as a fresh bill. Or it depends. And you know the workings of the National Assembly when it comes to that. I think he's a politician, and one of them can easily tell you this is the reason why they are doing this, and this is the reason why they are not doing it. Because I know of many instances where the president will refuse to assent to a bill and return it back to the National Assembly. It's president, and most of the time, which is expected, is by practice. Each time the president declines, there must be the reason for his decline, which may be in writing. And it's for them to not take it, look at it. Should we go ahead to toe his part of this is the reason, this is what he wants us to do, this is what he wants us not to do? Or let's reject whatsoever thing he's saying or he's writing.
Okay.
Let's go ahead and have our way. And all those things, it has to do with some political consideration. And so when it comes to political consideration, I'm a lawyer here. I'm not one of them. But any step taken by National Assembly, what matters most is that are they taking that such step within the ambit of the law? If that's what it is, then no problem. Somebody like me, I'll go with them. Because as a lawyer, your duty is to ensure that at all time, the law must take its course.
Because now you have a lot of people saying that about 70% of them might not return back. So was it that they actually got a premonition that this is how the suit will definitely end? Or like some people have said, that probably they shot themselves on the foot.
Well, that's why I told you that when it comes to this, it is more about politics.
Okay.
It's not about interest. You cannot take their interest away. Now, which interest they are taking and which one they are not taking is what you and I cannot say. Whether they are but we must be sincere. The National Assembly in recent times seems to consider the interest of Nigeria above any other interest. We have seen that in some of the things. Let's be real. Most of the members are friends to the governor, and they can easily have their way by conniving with the president, with the governor, to make some laws and to agree with the governors. But they choose to think of what is practicable, what tomorrow we can say we've been able to do for our people, and that is what is done here.
All right, now let's talk about the Electoral Act. Just walk us through on the new electoral laws. Now we know that in every election or after every elections, there are always buckets of lawsuits that are always waiting and lying around. And then with all of this, how much will, two questions, and I'd like you to unbundle them in one breath. Now, how much will the electoral law actually impact or operate on in this aspect, and also with these humongous defections that we always see from one political party to another by public officers? How much will the new electoral law actually affect all of this?
Well, you know, we've been having electoral law. This is not the first one. And what that one has been able to say is that there's nothing in this world is not everything in this world is subject to change, because change itself can change. And each time there is a law is a reflection of what collective interest, aspiration of the people. And if you remember, some years back we have a law, now we have a new one, and that is just to take care of something. And I must be sincere, not that the other law were totally jettisoned. There's some provision, but the only thing that you can see that there are some salient issues, new thing that could be highlighted from the new Electoral Act. Like for example, you mentioned like for example, you talked about the issue of litigation. Now, it has been able to, the National Assembly through this Electoral Act has been able to reduce some issues. For example, who can go to courts? With which of the forum of the court before it is High Court, State High Court, and Abuja FCT High Court, and Federal High Court. But with this new Electoral Act has been able to reduce all those pre-election matters to federal high court alone.
Okay.
That is one. Secondly, even those who can go to courts. For example, I've been hearing everywhere, it is one will tell you, Tinubu has this, that one has this, we are going to court. I'll be laughing. Because now it is the aspirant that took part in that is primaries that has locals to go to court. Though I've queried that, because I mean that, so if Evans, who has been convicted as a kidnapper, a notorious kidnapper, should take reform today, and by and large, nobody contested with him, is that the way we go for the election, without any challenge, or without any challenge from somebody like you, or from me, particularly where most of these qualifications are constitutional, are what constitutional stipulation, which there are many electoral authorities that says that when it comes to constitutional issue, everybody can have a bite and to query it. But in the situation now that when it comes to issue of qualification of candidates, the law is now saying that only those, the aspirant that contested with them, will be the one that can query such issue that have issue with them. But by and large, that one for some point has reduced the space of litigation left and right.
Okay.
Since now, that's why you see now that nobody has been able to query anyone to say this candidate is not qualified, that is not qualified, because one of the consideration would be, are you one of those that contested with him? If you don't contest with him, why are you saying that? I think that one is by the side. And again, you can see that the law, even that when it comes to their finance, it has been so clear that the fund for any preceding election, a year before the election, the fund must have been ready.
All right.
That one has been able to say that then the issue of logistics, there will be no problem. To say we are just trying to think, we are trying to raise some money from the National Assembly. No, there will be, so their funding should not be issue. So this means that election issue is a big issue that must be given a premium attention. And that's funding is there. And many other issues that are in the Electoral Act, which is, we can say, is a new one. For example, now, to determine whether there's overvoting, it is not the total number of the voters, but accredited one. Because most of the time, the voters, you find out that sometimes in the state, they have 5 million voters. But to those that will go for the election, that will come on the election day, they're not even up to 500,000. And so to know what is voter of whether there is overvoting, and you want to use the total number of voters, then you know you are not getting anywhere. But what should be determined is the accredited voter, the voter that show that turn up on the election.
All right.
Those are some of them. Say with some other things.
All right. We'll do for a break. Let's go on this short break. When we return, we'll definitely expand this conversation. I'll see you shortly. Don't move a muscle.
It's as simple that two of us, we decide to cook a soup of ogbono, and we give it to someone, and that person started complaining that he's having running stomachache, and I now decided to sue you for causing the stomachache. I know the first thing you just say, what's happening, Barisa? We cook this food together. Why are you suing me? You know what? That is exactly what happened.
Okay.
So if the president and the National Assembly should cook the soup, and we Nigerians are having running stomach, it is not the president that will sue National Assembly for it's two of them. You know that I think on a lifetime note, that's the best way to explain what one is trying to pass across.
All right.
At Monday's proceeding, Chief, who led 33 other senior advocates, had sought to argue the originating summon in the suit that was filed by another senior lawyer, Sebastian Horn, son, in line with the practice direction of the court. He argued that the current economic reality in the country requires that the salaries and allowances of the nation's judges be urgently improved upon.
Judges are also earning higher than our judges here. And the Nation newspaper commended me in an editorial. It has been on my mind, and the National Assembly and the Revenue Commission have continued to deter and refused to increase the salaries of justices and judges.
Pay a judge 500,000 naira a month, which is not enough even for counselors. We need to secure the future of judges, because when you secure the future of judges and judicial workers, you secure the future of justice, and then you secure the future of the people, and then you secure the future of democracy. One without the other is not ever possible. That is why we're in this struggle together.
The National Assembly, through its counsel, Mr. Charles Yoila, told Justice Otusatohanwe Obaseki Osagi that the institution is interested in an out-of-court settlement policy because of the nature of the matter.
Of the Constitution, this is a matter that relates to the welfare of the judiciary, the third arm of government. It is such that both the executive and the legislature must give serious attention, and from the indication, the National Assembly is not contesting it, it may not contest it. The Attorney General of the Federation is not here, but he has been served duly, representing the presidency and the executive. The National Judicial Council is also the institution created to protect the rights and welfare of judicial officers.
They won the call to compel the defendant to raise monthly minimum take-home of a judge of the NIC to 9 million naira, 8 million naira for Chief Justice of High Court of State and the Federal Capital Territory, while other judges are entitled to 7 million naira.
If you just joined us, this is The Conversation. We are reaching you from Captain's Television here in the nation's capital, Abuja. If you just joined us, you missed quite a lot, but you can still join in the conversation. Our guest on the show tonight is Dr. Olukayode Ajulo. He is a lawyer, and we've been discussing a lot of things. So before we went on that show, we talked about quite a lot of things. Now let's talk about one thing that has been creating quite a lot of dust and fuss to the polity with regards to the arbitrary substitution of names by political parties to the electoral umpire, and then they say that they are not ready to recognize such people, whether they did not, if they didn't attend the primaries, whether for whatever reason, even if whether the reason could be salient reason, or if maybe some people say maybe could be they found a criminal case or any of such. So how much does the new electoral law actually frown at this replacement of names?
Well, I will not say, I may not agree with you that there's arbitrary substitution, because the only thing is, there are some things that happen because of lack of vigilance. They have their ways. Yes, there are some times where political party without primaries will quickly change because there's a window to change, to substitute. But with this new Electoral Act, it has made it so clear that they don't call it substitution again.
Oh, okay.
In this new Electoral Act, there's no name for substitution.
Okay.
It is clearly two things. It is change and what can amount to change.
Okay.
It is not about want to substitute, except these two things happen. By the Electoral Act, it's either the candidate died or he withdraw, that you decide, I'm not doing again. So it is not left, because before, what normally happens is that you bring someone, I like your face, I want to substitute your name with mine. There's nothing for that again.
Okay.
What matters most is that to say you want to withdraw, then you withdraw, and the way and manner you do that is different from the way it is done. Now, it has to be written. There must be a letter in your own hand to be sure that it's voluntary, not that you are casual or somebody behind quickly change your name. Apart from that, there will be an affidavit to that effect, which you have to be sworn before the law court to state that, yes, I'm no more doing, I'm tired, I don't want to have anything to do with this. Then these two things will be sent to your political party. Your party will now take it to the INEC before they can now think of, then there will be a window to now say, let us, since we don't have a candidate, let us bring another name.
Okay.
Now, if it's a candidate, full candidate, what will happen is for the party within 14 days to have another primaries.
Okay.
That is in the event of that. Even in the event of withdrawal, the same thing. Unlike before, that when you withdraw, you quickly look for them. But where such withdrawal may not take place is where this one is for those who became a candidate through primaries. You know, there are two ways you can be a candidate by this Electoral Act. It's either you are a candidate having been elected in the primaries of the party, or you are a candidate by nomination.
Okay.
For example, all those presidents and the state governors being principal, they are always elected through primaries. There will be a primaries. Or those they are deputies. Deputy, they are being a candidate is not through election, it's through nomination. So in a situation where those subordinate, those vice, maybe they decide to withdraw, instead of going for another primaries, the party can substitute their name.
Okay.
But that one can only take place if they've emerged from a primaries.
Primary. Okay.
And like one of the things I raised recently, I want to believe that this is about issue of law. For you to be a candidate, there must be some constitutional stipulation that can make you to be qualified for that election.
Okay.
In a situation where a non-qualified person is nominated to be a candidate, can non-qualified person be able to bring another qualified person? That is the one issue of law that I raised out recently, which I'm looking for answer to, which nobody has been able. But as it is, this new Electoral Act has really made it so a bit harder, unlike before, for you to substitute. Even like I said, there's no word for substitution there. People can just play because if the law permits someone to withdraw, then you can have your private dealing to now cite. You can cite yet or anything to say I'm no more doing it, so that the next person. But even if you are now, if you withdraw, it is not that certain that the person you withdraw for will be the person that will emerge at the end of the day. I think you understand what I'm trying to say, because if you are like a president, I was someone a presidential candidate and say, I'm no more doing again. Having in mind you, and again, since the law says there must be another primaries, if that primary should take place, if somebody is stronger than the person you are targeting, cannot make it, that is where, unlike before, where before you substitute, you know who I substitute for. I say I'm substituting for this. No.
Okay, so how about the place? Does the electoral law actually frown at placeholder?
That's the same thing I'm talking about. There's no room for substitution, no room for placeholder.
Okay.
There's no room. But what the law has now is you can only stop from being a candidate either by reason of death. Of course, you can make someone who's dead a candidate, or by withdrawal. And when you are withdrawing, not that you say I hereby withdraw for so. What happens? I'm not doing again. Then let the law take its course to fill a replacement.
Okay.
Unlike before, where someone will be targeted and I'm withdrawing for so person. It is not done again.
Okay. Now I saw a particular writer that quotes and saying, it was actually quoted that you said so. So we'll find out if you were the one that says so. He says, and quote, "It appears as if the president is suing himself since he also assented to the Electoral Act in question. But then if the popular saying, no man is an island of knowledge, anybody can make mistakes. So is it wrong for the president to make a mistake with regards to the Electoral Act and decide to amend it?"
Yes, but what we're saying is this. Yes, I don't want to believe president makes mistakes. But if president should make mistakes, there are other way to rebut that. He can lobby, he can cajole them, he can talk to their senses. He has a way. He's the leader of the party. Or let me say he's the leader, of course, of the ruling party. But not to take recourse to court. Because when you take the cause to court, the doctrine, the principle of law will take its own course, and it will not help you. And that's why some people always take recourse to arbitration. Because if you should take me to court, that means that you sign off, or you have agreed that it is the principle of law that will govern whatever we are doing in the law court. But in a situation that maybe we have alternative dispute resolution, we look for a way. As a president, of course, do you know sometimes most of those dinners president do have at the villa is to feed the honorables? Do you want to tell me that they are hungry? It's another way. It's part of the politics, another way to bring them together. Reason with me. Let's do it this way. After all, if it works, it is the majority. If it has a way of lobbying them, although some people will tell you that lobbying is not in our law here, but there's a way he can talk to them. That's why they have caucus. You can call the caucus this law, this or less reason. Okay. After all, here is not about principle. It's about what the legislator says. And if they agree, they will change. But to take them to court, then the principle of law will take its effect. And that's when the issue will be that can you appropriate and then reappropriate at the same time? Can you sue yourself? Because both of you are partners. It's as simple as two of us, we try to cook a soup of ogbono, and we give it to someone, and that person started complaining that he's having running stomachache, and I now decided to sue you for causing the stomachache. I know the first thing you just say, what's happened, barista? We cook this food together. Why are you suing me? You know what? That's exactly what happened here.
Okay.
So if the president and the National Assembly should cook the soup, and when Nigerians are having running stomach, it is not the president that will sue National Assembly for it's two of them. You know that I think on a lifetime note, that's the best way to explain what one is trying to pass across.
All right, then let's divert a little bit and talk about the recent disquiet in the judiciary with regards to the controversial memo or letter. Because I'm sure that a lot of people actually did not see that letter or that memo coming, but somehow I feel like barmen saw it coming.
I don't want to discuss about the letter, because the letter is more like an indictment of two law lords. It is even in NJC, whenever you discuss issue of law, issue of judges, lawyers in their midst, they are always excused to go. Which of course, what many people don't really know is this: for you to attain to be a judge in Nigeria or anywhere, it's a big responsibility. They are doing a lot, and that regard must be taken. I don't think it falls within someone, a mere mortal like me, to discuss about accusation and counter-accusation of my lords. They are up there, and let their peers discuss it. We are not peer. We are not at par. I'm not their peers. They are the senior, and let those that can say we are peer to do that, not a mere mortal like me.
All right. So with all of that, do you actually think that it will in any way affect the rule of law? It would affect justice and equity and judicial independence, like some of people have actually said? Because that's the first time we've ever seen such.
But discussing that is as if I'm still discussing the issue. Like I said, I don't think it is within my station in life to discuss that. I think it's just like a personal principle, personal undertaking I've taken. There are some things I do, there's something I don't do. If, like, for example, if my dad and my mom should have any issues, I will never try to be I will never to be a judge in their matter. Is to look for maybe an auntie or an uncle to look at it. And I think that is the way. Respect must be accorded to their office. It's an exalted position. As a lawyer, I know what it takes to be a lawyer alone, not to be a high court judge, not to be a court of appeal judge, and to now rise above board to now be in Supreme Court. It's huge. It is just unfortunate. That's why some of us will always take it when they are being accused of taking bribes. I say, at that position, I don't always want to believe that. Though there may be an exemption to do, but I don't want to believe that. So any issue that happened between the justices, I'm sure they have a mechanism. Okay. I read it somewhere that even my lords, one of the former justice of Supreme Court, that my lord, now the Emir of Lafayette or Nassau, my Lord Justice Bagge, is saying to ensure that the matter is resolved. Fine. I even learned that I spoke with one of the senior counsel, Chief Awomolo even told me that their body of benchers we look into the whole issue. Those are the institution, people that I believe this question you should ask such people, because they have both constitutional, both conventional and moral authority to tap into it, but not me.
All right. Very quickly, as we begin to round up now, we saw that the Chief Justice actually resigned, and then it was reported that he resigned due to ill health. And then now we saw the reports were saying that we have Justice Olukayode, who will now be taking over from him. So what are your thoughts on this?
Well,
very quickly.
Let me quickly say this. I've come to know my Lord Justice Tanko as a young lawyer from the Court of Appeal. I've appeared before him for some time, and I know the kind of person he is. Yeah, and because of the issue of Nigeria, I want to believe, particularly when he resigned due to ill health, it is something that can give some sober reflection. And the only thing I need to say is to pray that may the Almighty God grant him good health, his soonest recovery, and I pray he will still have to do a lot of things for Nigeria in his capacity, even as a former Chief Justice of Nigeria. I think I salute him. Now, there's a new dawn. The new person has been sworn in as acting Chief Justice of Nigeria, my Lord Justice Olukayode Ajulo. He's someone too that I've known for quite a while. He's a very resolute judge, and we need to read some of his judgment. You know that you cannot but to salute his hard work, his scholarship. You need to see his in-depth reflection on issues. It's so great. I want to believe it's a new dawn for Nigeria.
Okay.
He has been an upright judge, and I want to believe that his personality will put to bear in administration of justice, and most of the issues that have been plaguing judicial system in Nigeria, it will come to clean it up. It will come to do justice, even in the hallowed chambers of justice.
Okay. Now, one last question before we let you go. With regards to the electoral law, now some people will say that phrase, the labor of our heroes past shall never be in vain. Would you actually say that this new Electoral Act, it has actually captured that phrase, the labor of our heroes past shall never be in vain? So what they labored for, the kind of democracy they labored for.
Yes, I want to believe it will not be in vain. The essence of it not being in vain is to get our democracy experimentation right. As long as we continue to do that, the labors of our hero past will never be in vain. But as long as we have what we have is incredible election, not free and fair election, then the heroes, those who are dead, will be turning their grave to say this is not the Nigeria we plan for. The Nigeria we plan for is for where we get our issue of leadership right. Nigeria is where things work. We should have election. 2015. I was an international observer in the United Kingdom in the general election. I saw the way election is, and I didn't know when I claimed to tell some of other observers from other countries to say, wow, if this is the way the election should be, then what we have in Nigeria in the name of election is civil war. And they were looking at me and say, am I sure? I said, yes, because you don't see police around. Just one very little venerables of one local church, you saw him putting the whole ballot boxes in his Zoom vehicle and drove down to where we want to vote without one single person going with him. I was even querying that, how am I even sure that this thing has not been tampered with? You need to see the way it turned green, and everybody started telling me that no, it can never happen. It can never happen. And true, you need to see how everything, I wish one day such thing will happen in Nigeria. So I think until when we get to that point, then we can easily say the heroes of the labor of our heroes past is not in vain. But as long as we continue to have election where it will only be determined by the amount of money you paid, then our heroes will be turning their grave. I saw what happened in Ekiti, and it is so clear that, like what I told someone, I liken that one to even a coup. Because when you plan coup, you use gun and jackpot to have your way. So if somebody is using money, cash to have this. What is the difference between planning a coup and do this in the name of election? That is not election. That is just buying and selling, and I don't think this is not what our nation deserves.
Thank you so much for your time with us, Dr. Olukayode Ajulo. It's been a wonderful time having this talk with you.
Thank you. I'm very grateful.
All right, viewers, that's where we end today's conversation. Thank you so much for tuning in. We have been chatting with Dr. Olukayode Ajulo. He is a lawyer. It's been a wonderful time here on The Conversation. I'll see you again next time from the nation's capital, Abuja. I am Annabelle Oji. God bless Nigeria.